Good evening. Thank you for signing up for Introduction to Immigration and Asylum Law. We're joined this evening by immigration attorney Bomy Hwang of Hiscock Legal Aid Society, which is located in downtown Syracuse. Bomy will be discussing her organization's work in our community and will then give a basic overview of certain areas of immigration law without delving too deeply into specific issues and potential legal scenarios, just in an effort to keep the presentation lean. There will be room at the end of the presentation for questions and answers. And of course, we're very grateful to Bomy for sharing her time and expertise with our community. Now I will get out of the way and cede the screen to Bomy.
So thank you very much. I really appreciate Manlius Public Library's invitation for me to be able to present on immigration law. And I just want to briefly introduce myself. My name is Bomy Hwang. I'm an immigration attorney for Hiscock Legal Aid Society. So Hiscock Legal Aid Society has several civil units that we assist on different matters. And we are a nonprofit legal services provider, so our services are free. And in our immigration unit, we have 9 immigration lawyers. And although our other departments serve a relatively small portion of New York State around Syracuse in the central New York, our immigration department is able to serve a bigger area. So we do serve central New York, Mohawk Valley, and the North Country. So I just want to put a quick disclaimer that this presentation is not legal advice. It's only for informational and educational purposes only. So we do recommend that if you have any question, that an attorney should be contacted for legal advice. My general overview of tonight's presentation is that first I'm going to discuss asylum and refugee status. Go over the terminology, how they are different, and how they're similar, things like that. And then I'm going to go cover a topic called temporary protected status. And then within that, I'm going to briefly discuss some Central American countries that some have the temporary protected status designation and some do not. So I'm going to discuss that briefly. And then the next topic will be humanitarian parole, which is one of, there are different types of parole, but humanitarian parole is one of them. And I'm going to discuss a bit about that and then go into discussing the situation in Afghanistan and how that is currently going for the United States to assist the Afghans. And then I'll have questions at the end. And I'm sorry, that survey should not be there. So there is no survey. Okay, so first, a refugee. The definition of refugee, these are the components. So a refugee is a person who is not able to, who is unable or unwilling to return to his or her home country. That person cannot obtain protection in that country due to past persecution or a well-founded fear of being persecuted in the future on account of race, religion, nationality, membership in a particular social group, or political opinion. I know that's a mouthful. There's a lot of components there. It's someone basically who is at risk of human rights, serious human rights violation, that the risk to their safety and well-being in life are so great that they feel they're forced to, they have no choice but to leave their country and seek safety in another country. So they could be refugee based on something that they have experienced already, a form of persecution, or it could be based on a fear of persecution in the future. And it could be based on those 5 different grounds. One requirement is that a refugee cannot have firmly resettled before going to the country where they're destined to go as a refugee. So there are different definitions of firm resettlement based on whether it's refugee or asylum seeker. For refugee status purposes, if the refugee has been offered or has received permanent resident status, citizenship, or some other type of permanent resettlement by another country, and also enter that country as a consequence of flight from persecution, then that person will be considered to have firmly resettled in that country. Because refugee law is international law, this presentation, when I discuss refugee, I'm discussing in the perspective of the United States as being the country that is receiving the refugee. So I just want us to keep that in mind. That is what refugee is. And if we look at the definition of refugee, the 5 grounds, which is the race, religion, nationality, membership in a particular social group, or political opinion, it does not have any reference to economic situations. So I think that is quite glaring omission in the definition of refugee. And there's no such thing as economic asylum. So the definition of refugee fails to recognize economic drivers of displacement. So those who are fleeing poverty in their home country so that they can improve economic situation are considered economic migrants, but not refugees. And also, it's important to keep in mind that the definition of the term refugee is from the 1951 Refugee Convention, which is a legal document that was put together after World War II. The countries came together to write up this document to address post-war humanitarian catastrophe so that they can help resettlement for those who have been displaced. But in terms of after, since then, more than 70 years have passed. And since then, economic crises have been occurring in a much more serious degree. So, like, for example, after the COVID-19 pandemic has hit, the economic situations has been exacerbated for many individuals who have been fleeing their home countries for that reason. The next one that I would like to discuss is the asylee. So asylee is a person who is seeking asylum. And asylee is somebody who meets the definition of refugee, but then there are other additional components. So asylee is somebody who is already in the United States and is seeking admission at a port of entry. So the person, and also similar to refugee, the person cannot have firmly resettled in another foreign country. But for asylum purposes, firm resettlement does not have that additional requirement that the person did not enter that country as a consequence of flight from persecution. So for firm resettlement, if the person was offered or received permanent resident status, citizenship, or some type of permanent resettlement in that country, then that is enough to to satisfy the definition of firm resettlement, and therefore will not be eligible for asylum relief. There are many benefits of asylum and refugee status. So it's a really big benefit for person to be able to petition for their spouse and unmarried children under age 21 to join them. And with the status of asylum and refugee, they are immediately authorized to work. So I do want to add that for asylum status, it takes quite a long time for the government to review and process an asylum application. It could take years, usually it does. And a person can request work authorization after their asylum application has been pending for 1 year. So they can seek a work authorization in the time that they are waiting. And then, of course, once they receive their asylum status, they are immediately authorized to work automatically. Both asylum and refugee status provide path to permanent residency, which is also, I guess, more of a legal term that's commonly referred to as the green card. And also, after a certain number of years of holding on to green card, the person can later on apply for citizenship and even be naturalized. As an asylee, they may apply for a green card 1 year after being granted asylum. And although there some adjustment of status, so that's another term for becoming lawful permanent resident, unlawful entry can be a bar to adjusting status or becoming lawful permanent resident, but as an asylee, unlawful entry is not a bar. So if a person has crossed the border without any authorization, visa, or parole, or any permission, they can still, if they have been granted asylum, they can become a lawful permanent resident later on. And as a refugee, the person must apply for a green card 1 year after coming into the United States. So there are a few differences between asylees and refugees, but as I discussed earlier, the definitions are quite overlap with each other. And the differences are really just procedural, that for asylee, the person who is requesting asylum is in the United States. And the person may be already in the United States without any lawful entry. So that could be the situation for asylee. But for refugee, the person has requested protection when they were in another country outside of their home country, outside of the United States. And so they have the paperwork has already been processed for refugee, and security screening has already been completed before they enter the United States as a refugee. I'm going to discuss the asylum processes. There are 2 paths that a person would take depending on where they are or whether they are in removal proceedings. So a person will be taking something called affirmative asylum process if that person is not in removal proceedings, which is another word for deportation proceedings. The person would be in defensive asylum process if the person is in removal or deportation proceedings. So for affirmative asylum process, the application is filed with and processed by the U.S. Citizenship and Immigration Services, commonly called USCIS. And the form that is required is Form I-589, which is called Application for Asylum and for Withholding of Removal. And usually the requirement is that if an individual is seeking asylum, they must generally file the Form I-589 within 1 year of arrival to the United States. And I mean, there's an exception to the 1 year filing rule, and there are 2 components. So one is if there are changed circumstances that materially affect their eligibility for asylum, or there were extraordinary circumstances that relate to the delay in filing. And then the second component is that the filer, the person who's seeking asylum, has filed within a reasonable amount of time given those circumstances. So given these very, I guess, vague languages, it is immigration attorneys just state outright that it's like a 1 year requirement practically, that when a person wants to file asylum, they should do that within 1 year of entry. And the thing about asylum, which is very beneficial for many individuals in the United States, is that anyone can apply. So even if they are here unlawfully or currently, or if they're here unlawfully, or if they entered unlawfully, they can still apply for asylum. There's no bar to that. The defensive asylum process is with the Executive Office for Immigration Review, EOIR, which is a branch of the government that houses the immigration courts. So immigration judges are part of that. It's the same as the affirmative asylum process in that the form I-589 is also the one that would be filed. And a person would be in the defensive asylum process in either one of the two ways. So one way that a person could be is that the person is in removal proceedings or deportation proceedings, either because they were apprehended in the United States or at a US port of entry without proper documents that shows their legal status, or if they are in violation of immigration status. And if they were apprehended in that circumstance, they would be placed in removal proceedings. Or the other way that they could be in removal proceedings is if they were apprehended by the US Customs and Border Protection, or commonly called CBP, while they were trying to enter the United States without proper documentation, or commonly called people who are trying to cross the border. So if they were apprehended in that situation, they would be placed in expedited removal process. And if they were found to have a credible fear of persecution or torture by if the asylum officer finds that the person has credible fear of persecution or torture in their home country, then the person would be placed in removal proceedings and then be adjudicated in front of an immigration judge. So that's one way why a person would be going through a defensive asylum process. The other way is if the person, if the case was referred to an immigration judge by the USCIS after it has determined that the applicant is ineligible for asylum after adjudicating on the merits of the affirmative asylum process. So it would sort of be like the appeal process of the decision. And the cases will be heard in adversarial or court-like proceedings. The closest immigration, or the court that adjudicates most, if not all of these removal proceedings, is the court in Buffalo, New York. So that's the one that would normally be where clients would show up for us. I'm going to discuss briefly about access to counsel in immigration court. So the current immigration system does not provide court-appointed counsel to non-citizens in removal proceedings who cannot afford a lawyer. So if somebody would like a lawyer to represent them, they have to pay for the lawyer, or they have to work with like free legal services provider like us to assist them. And this is true even for detained individuals. So even if they are detained and not able to move freely, they are not guaranteed counsel. So according to a 2016 study, only 37% of all immigrants and 14% of detained immigrants are represented by lawyers, which is quite a small proportion. And yet in every immigration case, the government is represented by a trained attorney. So it is far from being a fair adjudication. So somebody has written that immigration proceedings is like death penalty cases adjudicated in traffic court settings. So the consequences of deportation is very dire, and the way it's adjudicated is not fair, or it's not really thorough. So that's, somebody has kind of described it as that process. So deportation is classified as a civil rather than a criminal sanction, and that is why they're not afforded constitutional protections under the Sixth Amendment that are provided to criminal defendants. So I just want to go through quickly the few of the dire consequences that could result from deportation. So a person would be separated from family. If the person leaves the country and has children behind, the children's routines and relationships will be disrupted if the other remaining parent has to work, and the children are not able to participate in activities because the parent does not have time to take care of them for those things. There could be sudden and severe financial hardship. Housing instability could result, food insecurity could result. And also for the person who was deported and went back to their home country, the situation could be quite dangerous and turbulent. And there has been recorded instances of kidnapping, torture, rape, and murder. So the consequences could be very, very serious for deported individuals and their remaining families in the United States. So having counsel and having the individuals represented by counsel is not only better for the individuals, but also it's better for courts. So having a legal counsel ensures that the hearings are meaningful, and that the immigrants with attorneys fare better at every stage of the court process. So the legal counsel dramatically improves the individual's chances of successfully exercising their rights and options under the immigration law. And also not just for individual, but for the courts, the immigration court proceedings become more efficient because if the attorneys are there, they know the process, so they can maneuver through it with expertise. So it's been said that improving access to counsel and legal information could help decrease the immigration court backlog, which is at an all-time high right now. I would like to discuss temporary protected status. So temporary protected status, it's provided to nationals of certain countries. In the map that you see on this slide, those, I believe it's 13 countries. I'm sorry, yeah, actually 12 countries maybe. Those countries are currently has been designated for temporary protected status. And when the criteria under which a country receives that designation is that the conditions in the country is considered unsafe for the return of their nationals, or that the country is unable to adequately handle the return of their nationals. And so, for example, some of the reasons why a country will be designated for TPS is like an ongoing armed conflict. Also, which is commonly like in civil war or environmental disaster, like hurricanes, tornadoes, earthquakes, something like that, or an epidemic that would that would have disrupted the government functions or just the day-to-day lives of the people who are actually living in that country. Or if there's some other extraordinary and temporary conditions that prevent that, I'm sorry, not prevent, but that would make the country unsafe for their nationals to return. These temporary protected status designations they could be different, but usually it's a 6 to 12 or 18 months at a time. So they are very temporary. And although they can be renewed, it has to be evaluated prior to expiration, and the government could extend the temporary protected status based on the country conditions there. One limit or downside to TPS is that there is no path to lawful permanent residence or green card or path to citizenship for the people who hold this status. So what the government says is that if the person who has TPS needs to stay for, I guess, a longer period after the TPS designation has ended, they have to find another way to establish that, like a non-immigrant status or immigrant status in another way, or else they must return back to their home country. So the designation of TPS is fully within the discretion of the Secretary of Homeland Security. So it is up to them to decide when a country merits TPS designation. To be eligible for the TPS, the person has to be a national of a TPS designated country and need to be continuously physically present in the United States since the effective date of designation. The person must have continuously resided in the US since specified date, and they cannot be inadmissible to the United States for certain criminal or national security related reasons. So the process to apply for a TPS, it's not an automatic. So once the country is designated for TPS, it does not automatically confer the status upon the nationals of that country. So the person must register during a specific registration period, and they must pay fees in order to take advantage of this TPS designation of their country. If the USCIS grants TPS to the person, it has several benefits. One is a temporary stay of deportation. So they would be protected from deportation during that period. And the person has temporary authorization to work in the United States. And then the person will be eligible for advanced parole. So advanced parole is permission to travel abroad and return to the United States. So they would apply for advanced parole separately from TPS, and they would be requesting to leave and come back to the country without any issue. If they're granted the advanced parole, then they'll be able to do that. I did want to speak a little bit about the 4 Central American countries, specifically Guatemala, El Salvador, Honduras, and Nicaragua. So currently, there are the 3 of those countries. So El Salvador, Honduras, and Nicaragua are TPS designated countries. Current designation expires on December 31st of this year. And Guatemala is not designated for TPS. And it's been around the news the past few days where some US senators have called for the White House to act on, and they are requesting that the TPS designation for the 3 countries should be extended, and for Guatemala that it should be receive a new designation of TPS. And in that letter, they do describe how those 4 countries are plagued by economic circumstances, that there are issues of climate change, that for example, that there were hurricanes in the region recently, and that there's gang violence that are quite prevalent in all those countries. And I do want to mention that for Guatemala, nationals of Guatemala have very limited humanitarian relief and protection. If the person has entered the United States unlawfully, they don't have any really option in terms of humanitarian relief except for asylum. And because of the current asylum law, which does not recognize generalized violence in the country as one ground, and also like poverty alone is not sufficient ground, that it's very difficult to win if a Guatemalan national is applying for asylum, and especially if the person is in removal proceedings, it is even more difficult. And the situation is very dire, and by allowing those who are currently in the United States or who are from Guatemala, they can definitely benefit from the TPS designation if it does happen. So I would like to go into humanitarian parole. Humanitarian parole has been in the news since quite a bit since late summer. So I just want to go through what the eligibility is first. Although there are different kind of paroles, I do want to just focus on humanitarian parole this evening. And the person can apply for humanitarian parole if there is an urgent humanitarian reason. Although there's no statutory or regulatory definition of what urgent humanitarian reasons are, some of the factors that the USCIS looks at are how pressing the circumstances are, the effect of those circumstances on individuals' welfare and well-being, and if parole is not granted, what the degree of suffering that may result. So those are some of the things that they look at, and some examples of what could constitute urgent humanitarian reason is if the person needs protection from targeted or individualized harm, or if the person is looking to receive critical medical treatment in the United States, or if the person has a sick relative in the United States whom they need to care for, then those are some of the examples that could constitute urgent humanitarian reasons. One requirement that's required to obtain parole is the person must have proof that they have a means of support while in the United States. So this often means that the person the parolee needs to have a sponsor. And if the person is unable to provide any evidence that they have the financial means of support, then this may weigh very heavily in the decision of the government, and it could lead to a denial of parole. Parole is for a temporary period. The duration of parole is specified when it's granted, and usually it's 1 or 2 years, but I don't think I've ever seen more than 2 years. It's limited to the length of time that the government thinks that's sufficient to accomplish the purpose of parole. And during the time of parole, the person may obtain work permit to be able to work. So the person would file Form I-765 application for employment authorization, and the work permit may be granted. Some of the limits of parole is that as explained in the previous slide, it's a temporary lawful status in the United States. And technically, parole is just a permission for entry into the United States, and it does not confer any immigration status. There is no path to lawful permanent residence or another lawful immigration status or citizenship. So it's really temporary in nature, and there are really very limited benefits to parole. I do want to discuss the situation with Afghanistan. So following the withdrawal of the United States forces from Afghanistan late last summer, there has been a surge in applications for humanitarian parole. Usually, the government has received about 2,000 applications annually, but now there are more than 30,000 applications. The USCIS has been struggling to keep up with the applications, and it has resulted in a huge backlog. They have processed a very small percentage of the applications. Some of them approved, but many have been denied. So the situation is that if the Afghans are in Afghanistan, because the US embassy in Kabul is closed, and because the government requires an active US consulate to be able to process paroles, the USCIS says that they will not complete the processing. Like, for example, if the person is requesting parole is in Afghanistan, they can send the applications, but the USCIS will not finalize a decision. They will not give decision while the person, they're not able to give decision on the parole application while the Afghan is in the country. So what this actually means is that the person would have to depart from Afghanistan in order to be able to be considered and have a decision on their parole application. And the USCIS does not assist with leaving Afghanistan. They do not help those who want to leave, help them. So if the Afghans are able to leave the country and they go to another country, they have to be in a country that has a US embassy or consulate in order for to be able to file a parole application. So there's like a sort of like a catch-22 here, because if the Afghans remain in Afghanistan, they are continuously in serious danger. But if they leave to go to a third country, because that is the only way really for them to file an application and have it considered fully, then they're considered to be no longer in threat because they're outside of that country. So it presents a really very difficult situation for Afghans. I would like to provide my office's contact information. So if you know somebody who needs immigration-related legal services, then you can provide this phone number to the person, 315-218-0196. And we can provide free confidential consultation on an immigration-related matter. And we might even be, depending on, I guess, the nature of the matter and our capacity at the time, then we might be able to even assist just further than a consultation. And we have access to interpretation services for many languages. So if an individual is not able to speak English well, it's definitely should not be a reason to hold back from contacting us. That was all I had prepared for today. And if you have any questions, I would be happy to answer.